It's great to be here. Uh, what we thought is we'll do this a little differently, and first, because we have uh, four representatives from different segments of the infrastructure and energy business. We have representation from roads, general construction business, and renewables. One from the supplier vendor side and one from an IPP side. May I, I thought generally because this is a topic in the news, and what we find is that there is a lot of discussions, there is a lot of regulations, noises being made. But in terms of this session, we see it as an opportunity to share some day-to-day challenges which are being faced by various players in this sector, because as a practicing lawyer in this sector, there's a lot to learn from all of them, from my panelists, in terms of what they face from the business side, from the sales side, from the operation side. And that's something which we incorporate that into documents. We protect legal risk. We try and mitigate that risk wherever possible. But I thought we should use this session to exchange what ideas they have. And so to begin with, may I invite Mukul to share some thoughts on essentially give a background about some of the work he does, and what are the challenges he has faced, particularly from an investor point of view, from a PE funds point of view, because he's also seen a huge number of deals across his career. So currently, what is the challenges he faces from in implementation of these projects, and again, how does he envisage mitigating some of the legal risks? So thank you, Mukul.
Thanks, Prashant. And thanks everybody, and thanks Ligarera to host this. Now, interestingly, infrastructure is a buzzword nowadays. And we're all happy that Chandrayaan has landed successfully on Moon, and we hope that we'll have infrastructure on Moon also, and we can do something there. So infrastructure is the buzzword, and if India has to become a $5 trillion or $10 trillion economy in coming times, which we will be, infrastructure is going to play a very major role. And why it is so? Because there's a concept called multiplier effect, which means that every single dollar spent on infrastructure is going to boost the economy by 2.5 to 6 times, depending on what type of infrastructure we're investing in. So there are different economists and different studies. This means if I have to invest $1 or 1 rupee on infrastructure, the Indian economy, the GDP, is going to get advantaged by 3 times or 4 times. And therefore, we see the entire focus of government to make sure that India achieves this $5 trillion or $10 trillion economy is to spend that much more money on infrastructure. The entire plans, you see the NIP per se, the National Infra Pipeline, it states that in coming years, in a couple of years, they're going to invest almost 111 lakh crore rupees, which is a huge amount of investment. Now, if that much investment comes into infrastructure, it's going to boost the economy by 300 lakh crores, which means that India has to grow by 6%, otherwise it will grow by 9% per annum, the GDP. So there's a huge growth. So therefore, infrastructure is important, and therefore all these marquee projects are going on, like Chenab Rail Bridge, Brahmaputra River Bridge, and so on and so forth. There are so many. Likewise, we see the Bharatmala Pariyojana, the PM Gati Shakti Yojana, they all are linked towards the road and highway infrastructure, the logistics, and other things. So what I'm going to speak on today, or what at least I would like to use this opportunity for, is to...
Could you take the mic a little closer?
Oh, sorry.
Is it okay? No, it's on.
Oh, sorry, I don't know. I hope I was audible till now. So one thing is that infrastructure is one of the very important sector for India, and there's a multiplier effect for infrastructure. Now, coming to road and highway sector, the road and highway sector is a very critical sector because a lot of investment is going to come on here. But also infrastructure has been a very infamous sector in past. Many companies have burned their hands also, and people also have a lot of complaints about corporate governance. And therefore, of late, if you see, a new model has come up in this entire infrastructure side of road highways, as well as other energy and other infra side, is of InvIT and of REIT. And 2014 is when the InvIT regulation came into being. And after that, you see, in past 4-5 years, almost 21 InvITs have been listed in SEBI. And therefore, InvIT has been a very interesting model of investment into infrastructure. And as they say, the proof of the pudding is in the eating. If you see InvIT per se, InvIT has almost right now 1.1 lakh crores of fund mobilized in India, almost 40 lakh crore rupees of assets under management. So this means this is something which is a model as a corporate governance, as an infrastructure investment, which has worked for India in the past. So corporate governance is one side, but then what are the pain areas, or where is that this road highway sector has to go on and go forward? So if you see, when we invest into roads and highways, it is like if you are an InvIT also, it is regulated sector by two regulators then. One is SEBI, because we are InvIT, and second is the road and highway regulator, which is NHAI, if it is a national highways under the NHAI concession. Now, there is where the biggest problem starts for any developer, any player. So what happens is NHAI comes with bid for road projects. You as a private player, you bid for those projects. And initially, the entire thing is based on the DPR, the detailed project report. So NHAI will make a DPR, or the players will make the DPR, they'll agree. So the business people, they'll agree to certain things that, okay, we'll make road like this. And then they'll enter into a concession agreement. Now, interestingly, from a legal perspective, concession agreements now supersedes every single thing. Now, CA is what will prevail over. But for the business people who have been interacting with these regulators or with these bodies, for them, they are still so much casted in that initial discussion that they had, that, okay, if you will do ABC, then my responsibility is to do DEF. But the problem is, in the concession agreement, they will only write that you are supposed to do DEF. The concession has to do this. Now, when you have to do this DEF, and if the ABC is not done by the regulator or by the state, or if that support is not there, then you cannot comply with your regulations, or if you'll comply with at a higher cost. Well, then even the cost of ABC is onto you. And then when you start questioning these things, there is a problem. And then when it comes to legal department, it's a bigger problem, because then they have to interpret this based on that concession agreement which has been written. So therefore, there's a complete disconnect how it happens. And therefore, I feel nowadays the problem of investing in infrastructure is no more an engineering problem or a finance problem. We have engineering solutions, we have financial solutions, but more or less the problem nowadays is of a legal problem or a regulatory problem. So now we have to have a good legal engineering to ensure that these problems they are taken care of. I'll just pinpoint 2-3 major points of flaws which I feel are there at present in road and highway sector, which really pinches us the most. One is in the road and highway sector, the bigger, and then this is across infrastructure, the claim, when you file the claim and you get the claim, there's a huge delays. And a lot of companies in past have just failed because of these cash flow issues. If I have a claim of 100 crores and I need that money today, if I get that after 10 years, even the 100 crores is worthless because the company has died. Because that cash flow is the biggest problem today. I have to handle or tackle. I need that money today. So if that plant doesn't get water today, it will never become tree, and ultimately it will just die. So even that 100 crore coming after 10 years doesn't make any sense to this person who has a genuine claim. So one is that delay. And interestingly, from road sector, if you do a normal Google search, you'll find out if there are some 13,000 crores of claim filed, hardly some 3,000 crores claim have been settled. And that too, they are settled through CCIE. Now that is Consultation Committee of Industry Expert. Now why it is so? Because I feel that the bureaucrats itself are risk averse. They do not want to take any risk on themselves. As I said, if in DPR they have agreed to something and the concession agreement doesn't allow it, no bureaucrat is going to take the risk of allowing those things now. And therefore, the easier way out is you go to a concession committee, let the concession committee pass an order, or go to an arbitration, get an arbitration award. Now that is where I feel the biggest risk lies. And second pain point is that even the arbitration or these processes are taking a huge time. The problem in the Indian arbitration scenario is that we take one step forward and take two steps backwards. The recent amendment of fraud and corruption again is a very, it may be a step in the right direction, but I don't know, the implementation is again very poor. Because fraud and corruption is something which court cannot deal with in one hearing. It requires a mixed question of facts and law. So it requires some time to deliberate. And it's going to delay even the enforcement for some time. So therefore, for any infrastructure, because infrastructure otherwise is a long game, huge capex and long payback, and therefore these supports are required. The supports of making this DPR part of concession agreement, the support of of bureaucrats who are entrepreneurial bureaucrats who understand, who can take risks, and they are not punished for taking those risks. Third is, from the market side, at least the dispute solution has to be faster. As I said, it's not a legal problem more than an engineering or a finance problem. So this is what I want to leave this thought with here, that this is what the road and highway sector, the problem that we face.
Thanks, Mukul. So I think it was useful to hear from your practical experiences in terms of. I think you mentioned, primarily dispute resolution as something which can be improved, and I think that's a general pain point, which has been felt in this sector. So thank you again, for your inputs. So moving on to Sandeep. So Sandeep, is our expert, from HCC. So he has years of experience, particularly, handling various types of commercial disputes. So I'd like to invite Sandeep to share a few thoughts on, because just taking off from where, Mukul stopped, in terms of, the pain point obviously is disputes, and all of us know that there is an issue of, time, versus money, and speed, in disputes. I mean, we've experienced that there have been various avatars of the Arbitration Act which have come out, amendments which have come out. So I think it will be useful to hear from Sandeep on his experiences on handling various types of disputes. Some practical tips, if he can share with us on how do we save time and costs for clients, and some of the challenges which he's currently facing. So over to you, Sandeep.
Sure. Thanks, Prashant. And I think, Mukul, I'll take off from where you've sort of left. And one of the most important thing what I face in today's scenario is how to sort of tackle your dispute resolution mechanism within a particular time frame. Now, as you know, I mean, the infra contracts and all, they are pretty complex in nature. And it's also an element of time which is attached to it. So I think that's the main cause of dispute, because the complexity of the agreement, and then if it's a multiplier of timeline and all, which eventually results into delay. And whenever there is a delay, it goes into dispute. Whenever there is a dispute, it goes to the dispute resolution mechanism has to be followed, and then it's a long run procedure. And what I had practically seen, delays resulting to dispute and things like that, which has also resulted in termination of certain projects, making the contractors sort of bankrupt and all. And again, there is no particular mechanism other than the dispute resolution to sort of recover your money. So these days, what we are also seeing, especially in the contracts which are funded by World Bank, which is more than 50 million, and also in some of the railway contracts and all, so they are more focusing on multiple dispute resolution mechanism, which is a stage which is prior to arbitration. Which also includes appointment of engineers, appointment of experts and all, then the dispute resolution board, which sort of, which will help tackle the dispute in a timely manner. But again, are we fully there? We are not, because, given our legal system and all, we have a long way to go. But it's a welcome approach that, that our clients or some of the government organizations are looking into. I think the government is also well aware of the fact that, especially in the infra related contracts and all, there's a lot of pendency which is there in the court. And if I'm not wrong, I was written certain blogs and all. There's some 82,000 odd crores which are pending in courts to be paid to the contractors, right? So Mukul spoke about the CCA route, which was a scheme which was laid down by the government, by which you can withdraw 75% of your awarded amount by giving security. I do not know how many of you are aware. Recently, the government has also come up with an amnesty scheme, which is called Vivad Se Viswas scheme. This is all about in which stage your litigation is and how would you sort of withdraw the money. So just to give an example, if you have an award in your favor and you want to apply in VSV scheme, then you get 65% of the net amount. And when I say net amount, it is your claim vis-a-vis the other side's counterclaim, and it's net off and you get 65%. Plus you also get an interest of 9%. So this is, I think, a welcome thought for organizations or this is one mechanism which the contractors can look into whose disputes are not that old. And why I'm saying is because typically in an arbitration award, you have a pre-award interest and a post-award interest. And what I have seen in different awards, you get a post-award interest anywhere between 12 to 18%. So vis-a-vis that, if you're getting a 9%, then you take a haircut of almost 7 to 9%, depending upon your post-award interest element, into the multipliers of the number of years. So that itself goes to a big amount. And plus initial haircut of 35% because you're getting 65%. Now, the moment you cross the 34 stage or 37, it's all same. You get 85% of the award. So again, net of the award plus the 9% interest. So again, it's a welcome move. The government is also aware of the fact that, because of the pendency of the matters, the vacancy in the courts and all, a lot of litigation's been pending. So they're trying to clean up the thing. But again, we have a long way to go. In order to avoid all these things, I think what is very important is to get your contract drafted properly. I mean, it's easy saying because at least my organization, we mainly deal with the government authorities, right? So even to do some of the basic changes in the contract with the government authority, it takes a Herculean task. But things like if you make certain things mandatory, lesser use of words may rather than shall, have your dispute resolution mechanism properly sorted out, then the pre-arbitration, the multiple dispute resolution mechanism, which is pre-arbitral stage, that is well sort of, jotted down with a proper timeline and the consequences if it doesn't fall within that particular timeline. And also the choosing of arbitrator, how many arbitrators, the seat and all. These, I think these are all small things, but it takes up a lot of toll when you go into litigation. And of late, the government has also come out with the white papers in terms of the changes in the Arbitration and Conciliation Act. So as an industry, we've all given our thoughts on that. I think one of the things which we have seen from different bodies they have come out with is the timeline of completing the arbitration as well as the litigation. And so there are certain norms in SIAC arbitration when you can do it expressly. So we've also recommended for that. Let's see what the government or the regulatory authority comes up with. So net, I think if you can handle your contracts properly, if you have proper dispute resolution mechanism, which is pre-arbitration, and then, the all other, the mechanisms of negotiating with the clients and all, if these three can be taken care of, then you should be at a better stage compared to if you go into litigation. So that's basically my thought process.
Thanks, Sandeep. So I think it was very useful to hear from your experiences about at a practical level, how do we deal with this issue. And we are all the difficult part is we are in this sector where disputes form a very important part. Unlike other sectors where they may not have to deal with government entities all the time. I think we don't have that choice. Most of the projects are for the government, And because they are infrastructure, they are large projects, disputes are inevitable. So again, thank you again. I think our takeaways is that sort of focus on pre-arbitration, sort of convert those may to shall in terms of deliverables, and really sort of do the contracts a lot more seriously, and try and resolve those issues before it reaches litigation. So thank you again, Sandeep. So I'd now like to invite Sudipta, who is representing an IPP world, and moving away a little bit from disputes. It will be useful to get her thoughts on, as legal counsel for an IPP, what are her been experiences in terms of implementing projects, what have been the challenges contractually she has faced, also in terms of as we are moving away from a single contractor world to a multi-contractor world, and the world of sort of turnkey contracts is changing. How do they as a company manage this very big legal risk where there are multiple contractors involved implementing a project? It's not very easy, and they have to deal with regulators on one hand, they have to deal with multiple contracts on other, the number of pass-through risks which have to be thought of. So over to you, Sudipta.
Thanks, Prashant. Just to give a background, I work in the energy sector, and we are power producers. And like all infrastructure sectors, energy is also a heavily regulated sector. That's both a boon and a bane for our sector, the way I look at it, because it's regulated, but at the same time, the interpretation of the regulations, the way the regulations are introduced, often becomes a massive challenge for companies like us. And we have foreign investors in our company. So for them to understand what the sector is going to do tomorrow becomes extremely difficult. And I think that's one of the biggest challenge that our sector faces, is the regulatory policies and orders that are passed, which are passed for the benefit of the sector, but are passed in a very sporadic manner and not in a sequential manner, which makes the implementation extremely difficult. So that makes our investment into this sector very, very difficult, because you don't know where you're going to be tomorrow. So that's one of the biggest challenges that we face in terms of the regulations that govern us. Coming to Prashant's question on turnkey contracts and the move from turnkey to the split contract. Now, erstwhile, there was one big umbrella contract, and we had one EPC provider who would supply us the turbines, the panels, would erect it for us, do the construction, acquire the land, get the ROW. But I think Tapsi will highlight more on it, that from a supplier's perspective, the suppliers started realizing that that's not their core business. From an IPP perspective, we started realizing that you will probably incur less project costs if you split these contracts and have multiple contracts, where you're looking at a pure supply contract, you're looking at a pure service contract, you're looking at a BOP contract and a land aggregator. But then again, it doesn't come free of challenges. With the multiple split of contract, an IPP which was earlier just speaking to one person is now speaking to multiple contractors, and the seamless transfer of risk is also not there. So as the legal counsel for an IPP, I think it's very important that we focus a lot on these contracts and see how you can bridge the gaps between each of the contracts. But also at the same time, we need to communicate to the business team that it's not free from risk. It cannot be a foolproof contract, because at some point there will be a responsibility which will be the IPP's responsibility, and we need to look at those. So from a legal drafting perspective, I think it's very important to have your division of responsibilities very clearly mapped out, so that as an IPP, you know where your responsibility starts and where the contractor's responsibility stops, so that that gap doesn't lead to a massive delay or probably a fall of the contract, because that can happen very, very easily. So that's an important aspect. Again, dispute resolution, I think we've all spoken about it. It is an issue. I think in movies we always, we heard this dialogue saying Tariq pe Tariq, and it's really, really true, because I joined this organization 14 years back, and I still have a litigation which was started by my president, and I'm still following it through. So it's going to be close to 20 years, and we still haven't heard or had a final decision. So that dispute resolution quicker, I know every regulator is working towards putting a timeline. The Electricity Act is going through an amendment, and they're trying to expedite and putting a timeline that within 90 days, the ERCs must, resolve a dispute. But we've seen that with the IBC also. It had a time period, but I don't think that has ever been adhered to. So I don't know what's going to be a solution to this dispute resolution. I think it's best not to go into dispute, because then you'll be stuck for really long. But again, because in the infrastructure sector, you are working with government entities, you are bound to go to the courts, because no government entity is going to settle a dispute without going through multiple levels. Now, multiple levels also, you start at the base, and then, because they say as per our audit requirement, we need to go to the next level. And it ends up going to the Supreme Court. Every dispute goes to the Supreme Court. And I think at some point, the Supreme Court needs to decide that they are not going to start admitting these matters. And that's where probably the delay will stop. I think I can keep going on and on, because there's so much in the power sector that's happening. But yeah, I think these are the primary challenges that we see from a legal perspective. Now, if I was to wear a commercial hat and look at it from a business perspective, I think the renewable sector in India is booming. So obviously, investment-wise, it's a very exciting sector to be in. But then again, I think the regulators, the RBI, they need to look at making funding into this sector more profitable. I think right now the cost of funding these projects are also very high. The constant change and fluctuation in currency, our currency obviously not doing that great, impacts the project cost a lot. So a lot of work from that aspect needs to be done. I think government also went into the Atmanirbhar Make in India concept, where they wanted to promote Indian manufactured stuff. Now, when you come to the renewable sector, we don't have the capabilities to manufacture in India yet. Probably solar panels, but with the entire gamut of those panels, there are a lot of other equipments that need to come. And that kind of creates a lot of disbalance in terms of supply and construction. We need to import massively from China, but there are restrictions on importing from China. So I think when the government's kind of also passing these regulations from legal and both commercial perspective, I think implementation and the viability of these regulations is something that really needs to be looked in detail and and I think that gap, and I'm a big proponent of this, is I think the policy advocacy section is very important. As in, we as corporates need to work with the government and tell them the challenges that we face and have a two-way communication, so that these regulations, though are drafted for the benefit of the sector, sometimes become very, very disadvantageous for investors, because different people interpret it differently and it's not sequentially done. You don't know how it's going to impact the business. So it just becomes very haphazard. So I think, Prashant, if I keep going, we'll probably run out of time. So I'll stop here.
Thank you, Sudipta. So my takeaway is that one is, on disputes, try and not dispute it, or try and resolve it, before it enters, the dispute stage, which I think is a very useful, practical, advice. And two is, you obviously mentioned, back-to-back protection. And I think the important takeaway is that there cannot be any complete or 100% back-to-back protection. There is risk in the contracts. Help the business team understand that risks. You cannot get 100% legal protection. And the third, very usefully mentioned about what's happening in the contract space, the challenges with implementing contracts, and particularly the challenges of manufacturing in India. And a very important point you made was that that there's not enough manufacturing going on in India. So there is demand, but there may not be that much supply. And that leads me, to our final panelist, Tapshi here, who sort of represents, the manufacturing industry, the supplier industry, the OEM industry. And it will be very useful to understand from Tapshi here as to, yes, India has a lot of plans about manufacturing in India. We have Make in India, we have PLI schemes, we have so many incentives, but on the ground, there is not enough manufacturing happening. We are going to take a lot of time to get to those numbers which have been projected in various missions and plans. So it'll be very useful to hear from you, Tapshi, on what are the challenges you have faced in terms of your experiences as a supplier, as an OEM manufacturer, in terms of and again, something which we touched upon is again, you're moving away from a multi-contractor model to focusing on a single contractor model, where you're good at as a company. And, how do you manage then risks then, in terms of manufacturing? So over to you, Tapshi.
Thanks, Prashant, and good afternoon to all the audience here. So, one of my co-panelists said that renewables is booming now. It is true. And the Indian government has committed that it's going to reduce its economy's carbon intensity by 45% by 2030. And of this, 50% will be coming from renewable. I mean, the electricity base is going to be from renewable sources like wind, solar, and biofuels. I mean, these are the three main areas we see in India currently. I represent the wind industry, and I'm with GE, and GE is very committed to help the government of India achieve its commitments that it has made in its policies as well as in the Paris Climate Agreement. And to that effect, GE has already supplied, and we have products which is as big as 3 gigawatts of wind turbine projects in the country, and we see ourselves increasing and growing to about 5 gigawatts by next year. Having said that, as all our panelists spoke about, and especially Sudipta, who is from the IPP side, we face a lot of challenges, and she did touch upon why suppliers are now kind of changing the model in which we are doing the contracts. Yes, earlier, about 10 years ago, OEMs would be executing turnkey projects, so it would be end to end. We get the project, we go in, we get the land, we get the ROW issues sorted, the pathway issues sorted, get our equipment, install, commission, provide the service, and that would be at least from the start of execution to the end of services, at least a 20-25 year a commitment. But now the main challenges that we have experienced as OEMs over the last 10-12 years, the topmost is related to land acquisition. Because what's happening is that land that you require to set up your wind projects is agricultural land. And this is not a very organized sector. So going in, negotiating with the villagers, getting the land, buying the land, whether you lease it or buy it, getting title deeds in place, ensuring that there's a clear title that you can pass on to your IPP, who is the employer. That became very, very challenging, and we ran into a lot of problems because, again, for OEMs, land is not our bread and butter business. The next challenge that we faced, and which got intensified post-COVID, was, of course, the supply chain issues. We don't manufacture much in India. As per the guidelines, the RLMM is a requirement, which is, any wind OEM has to be necessarily RLMM listed, without which I cannot sell a wind turbine in the country. And that requires that I have a facility to at least manufacture my nacelle and the hub. But the rest of the equipment of the wind turbine does not need to be made by me in India. So a lot of stuff, a lot of the inputs, input materials, the towers, etc., are getting imported into the country. So when COVID hit and with the Ukraine war, the supply chain got impacted hugely. So that led to delays in execution and other complexities. So that was another big challenge that we faced. And the third challenge, again, which we faced mainly during the pandemic period, was related to getting labor, because you need experienced labor to go and execute the projects. I mean, to set up those wind turbine towers, and they are huge equipment. I've gone to our blades factory in Karnataka, and one blade is bigger than a football field. So, to pull that up, to pull it up with a crane on top of your tower and to set it up, it's a massive task. So labor, getting good, reliable labor was another issue. And there are various other challenges, but I think the other challenge that we face being a equipment supplier is related sometimes to product issues. And that is also because India is a developing wind market. And, the kind of wind that we have, it's what we call low speed wind. So our turbines have to be such that it complements to the low speed of the wind, that is, because that is what is going to lead to the generation of the wind energy. So if your turbine is not in line with the climatic conditions, the wind conditions, there could be certain challenges with the equipment that you go and install. So sometimes we get, product-related problems that we have to face with, and we have to deal with our IPPs and our employees. So in my experience, most of the legal challenges that come to my table are coming from these various factors. And with respect to, so my take and how I advise my business and how we have worked it out as a company is that, first of all, as a decision, we have decided not to get into the land space, because that is not our expertise. And we anyway had to be reliant on other subcontractors who were also not experts in, dealing with land issues. But having said that, me being the OEM and me having signed that project, I still have certain liabilities. So it's very important that equipment supplier also has a proper land team in place, which works with whether it's the IPP who's taking care of the land issues, or it's another subcontractor. It's important to get your land due diligence done very thoroughly, because a lot of times what's happened, we have acquired land, we have started executing the project, and suddenly some relative of another farmer has come back and said, hey, you have no right to this land because I was given the rights to this land years back through some power of attorney, that has been signed, etc. So getting land due diligence done, very important. Work with good real estate lawyers and have people in the local areas where your project is coming up who knows the language, who knows the authorities, and who can deal with it and help in getting this land. Second thing is with respect to supplier delays, etc. A lot of it is, was a result of the pandemic and the Ukraine war. So, in your contracts, I feel if we have a robust force majeure clause that takes care of this, and that is one thing. But I think the other important thing that needs to be in place is having a price escalation clause in your contracts. Most of our contracts are fixed priced contracts, and price escalation is now a topic that is getting discussed. How can we include that in our contracts? Because even if it is a fixed price contract, there should be a provision that, if the cost goes up because input materials, because of the delays, are also increasing. So there should be the ability for the parties to negotiate cost if a certain threshold is crossed, even though if it's a fixed price contract, and if it's open contract, then it's even better. So that is one thing. With respect to your product related issues, I think very important, your warranty has to be very smartly drafted. It has to be very clear on what the coverage is, what are the liabilities in case your equipment fails, or there's a problem, or there's a defect during the warranty period, and how much of your latent defects is also covered by the warranty period is something that's very important. And this gets, it's very important, again, to be open, discuss with your IPP partner, and draft your warranty clauses instead of just giving a standard thing that, okay, the warranty will be X number of years post supply of equipment. So that's another challenge. I mean, that's another way I think we can overcome contractual challenges. And coming to the disputes aspect of it, I think I can say this: in the wind industry, considering the nature of the projects that we are executing, our disputes are of a very techno-commercial nature. It's very complicated. I've been in this industry now going to be 4 years. And in this entire period, my experience has been, we work as partners. Of course, there are claims and counterclaims that are always crossing the tables. But typically, the players do not want to take a dispute into a full-fledged arbitration because you are stuck there. I got involved in one such arbitration. That was the only one arbitration that came up to my table in the last 4 years. But then we were lucky enough to resolve it, because even to reach that settlement, it took us 2 years, and during which time the arbitration was still continuing. I mean, we had just about reached, cross-examination by then. But so as players, we are more partners, and we try to resolve our issues by the end of the contract execution phase. And we generally try to avoid disputes unless you're really pushed to the wall and there is a really serious defect that needs to be looked into. With respect to the split nature of the contracts, yes, as OEMs, we have now become smarter, I would say, learning from experience. So we have kind of split up all our contracts. We are concentrating mainly on just the supply. Installation work also, which we used to do earlier, now 50% of that we do it. 50% of the times the IPPs do the installation themselves under our technical advisory guidance. Commissioning is always done by us because that's our equipment. And lastly, when all of that is done, it is open for the IPPs to come back to us if they want full services or operation and maintenance services from us, which again runs from anything between 10 to 20 years. Usually they'll take it because it's our equipment. But what we try and do is, by splitting up the contracts, we keep each of the contracts independent. There are no fallback clauses. There are usually no set of clauses against each of these contracts, and they're treated absolutely independently, separately, and they work in parallel. So yeah, that's a little bit from me, Prashant.
Thank you, Tapshi. So my takeaway is that deal with land, smarter contracts, is what you're doing. Better warranty clauses, and again, the message is don't get into disputes, right? Okay, so just a quick 1 minute from all of you, and I'll start with Tapshi, you, and we'll reverse the order. Is essentially, because we're also dealing with a number of legal consultants and advisors. any one sort of takeaway or message to your legal consultants and advisors who you deal with, because the focus is now changing, right? And like all of you mentioned, that there are different expectations from your legal advisors and consultants like us who are advising you on these projects. So just a quick 1 minute from all of you is, in your experience, what can be done better to help you with your legal solutions?
I think what I always tell my legal advisor when we go external, most of the stuff is done by us internally, is that, understand the core nature of our business, understand our project, the equipment, because if you don't have that basic understanding and the nature in which the projects are executed, we can give a lot of legal guidance, which may just become, good to follow, but not necessarily what we want to really do. So we have to be pragmatic. We have to understand how business goes on, the focus of the business, and accordingly, your advice should be such that, as a general counsel, I can, just go to my legal advisor and say, hey, this is the problem. How do you think this is the most practical way of solving an issue? Thanks.
Sudipta?
I think it's very similar to what Tapsi said. I think the consultants need to give a legal commercial solution. We no longer look for just a legal solution because we have in-house legal teams which have that expertise. We also have the commercial expertise because we are so close to the business and we understand the business. So we expect external law firms or consultants to come up with innovative ways of addressing a legal dispute, but at the same time, it kind of balances the commercial need of the hour as well. And especially when it comes to dispute, because that's something that we kind of outsource the most, and most of the other work is done in-house. Again, look at it from a more commercial perspective. I know every dispute can be argued in a court of law. As a lawyer, I always say, I can argue from both sides. Which side do you want me to argue? But when I go to you for an advice, I would want them to come back and tell me that, Sudipta, don't fight this litigation. It's not worth it at all. And that very seldom happens because I think everybody wants to go to the court and, prove their point. But that's really something that I'm looking for, at least someone to come up. It hasn't happened till date that somebody's come and says, Sudipta, don't get into this litigation. So I'm hoping that someday some consultant will be honest, come back and say that, okay, don't do this. And I'll be really happy to hear that.
Sure. Thank you. Sandeep?
So I would focus more on the external part because ours is more litigious as an organization. So one advice for the consultant definitely would be to go through the facts properly, because all the arbitration awards and all that I'm having in running into hundreds of pages. And if I am to appoint a Dr. Singhvi or Mr. Rodgi in any of the matter, they have that minimalistic amount of time within which you need to brief them, because again, it's the combination of the AOR and the junior coupled with the in-house team and all. So what I make it a point, none of those meetings are being attended without my team member or myself. So yeah, definitely going through the facts properly, because many a times you find solution within the facts. So you don't have to reinvent or invent the law.
Thank you. Smukul?
Yeah, so Sandeep, Sudipta and Tapsi, they've already spoken pretty well on this. This is what we expect from the lawyers. I'll just talk about the M&A piece. So when we have this M&A deals, I feel most of the time deals are stuck because the two lawyers will always take to very conservative position and will not let the deal go on. And then we have to intervene and somehow take some calls. I feel that at times it is not required because the lawyers are senior partners and they themselves can settle those things out. And they should keep the ego aside and just let the business deal happen. And that's what I like to advise. And I like those kind of lawyers who tend to solve things more than just keeping and giving a conservative. But the problem is in companies like ours, where we have foreign investors, if you have such a conservative opinion and if that opinion comes on record, it's very difficult for anybody like us also to take any call then. Then they'll say, when your lawyer is saying this, why are you just going and overruling it? Therefore, be practical in these things, and because business has to flow if anybody has to make any money.
Thank you, Mukul. So, thank you again. I think that comes to the end of our session. It's been a huge learning experience for me as an external lawyer.